Thank you for joining us tonight for our discussion on a recently passed Assembly bill in California, number 117. This Assembly bill, well, before we get into that, my name is Jodie Howard. I am an attorney and the director of the BREN Special Education Legal Clinic at San Joaquin College of Law. This discussion tonight is about that Assembly bill and the portion of that bill specifically talking about special education timelines amid the COVID-19 school closures. So we're going to start by looking at the actual language of the bill. So there are multiple sections to the bill. The section that we are going to talk about tonight is Section 8. That is the section that specifically pertains to special education timelines. You'll notice down here at the bottom of the screen that there is a link to access the actual bill. If you want to read the bill in its entirety, you can, copy down this link and it will get you to the bill. So this is Section 8. It has subsections A through E. We're going to spend a majority of our time talking about sections A and B because that's where most of the information lies as to how it specifically affects special education timelines amid these school closures. So we're going to start, instead of reading all of this all together, let's just start by focusing on Section A. So this is subsection A. And what it's really talking about here, let's look at those highlighted things. We're looking at how are we going to determine if a local educational agency or an LEA, oftentimes they'll be referred to as districts or SELPAs. These are all different LEAs. So to determine if your LEA is in compliance with special education timelines, that's what this is talking about. How are we going to determine during these closures if they're still in compliance? But it's not all timelines. So what you'll notice here is it's specifically talking about Section 56043 as well as 56321. So we're going to look at both of these. Let's start with 56043, but it's not the entire section. It's specifically referring to subdivision A. So I'm going to bring up the language of that subdivision here. 56043 subdivision A is talking about when there is a proposed assessment plan. So those of you who have taken my class at San Joaquin College of Law, you already know that IDEA tells us if a parent feels like, or even the school district, if somebody thinks there might be, a developmental issue with a child and they may be served by special education services, then we have to put together a proposed assessment plan. Now, normally the school has 15 days, 15 calendar days. From that, we call it a referral. When somebody approaches the school district, or if the school district approaches the parent and says, I think my child might qualify for special education services, it automatically starts this 15-day clock. Schools under IDEA law are supposed to put together a proposed assessment plan within 15 days. So that's our current law. Also, though, embedded in our current law is this language. Any time between regular school sessions does not count against that 15-day calendar. So that would be things like winter break, summer break. It's usually anything in excess of 5 school day vacation days. So even Thanksgiving break, if your Thanksgiving break is a week long, would be considered one of those times between regular school sessions, and we do not count those days against that 15-day calendar. So no matter how long the closure is, as long as it's 5 days, that's what our Senate bill is telling us. Let's look back up at the Senate bill law language. So this section up here, remember, is the new law according to our new Senate bill, at least during these closures. What they're saying here is we're going to consider the days a school is closed because of the COVID-19 crisis as days between the regular school session. So no matter how long our schools are closed, they do not count against this particular calendar of when the school district district has to put together a proposed assessment plan. Now that makes a lot of sense, because how can we really assess a student if there's no classroom to assess them in? So there's many components to a proper assessment, which is another class in and of itself entirely. But just to very briefly talk about it, an assessment plan has to be sufficiently comprehensive. And one of the main components of that is to watch and observe how the child interacts with their classmates. How do they respond to class instruction? And we can't really do that without a classroom setting. So that's a major component of a traditional assessment that is not going to be available to us during this closure. So I can see some wisdom in stopping the clock, so to speak, on that. So that's what this section is. So we're going to start this checklist, I guess you could call it, of which timelines are actually affected by our bill number 117. So this first one is the school has to develop a proposed assessment plan within 15 calendar days. But if you look down here, our bolded language tells us that we don't have to count these COVID-19 closure days as part of those 15 calendar days. So it effectively stalls or stops the clock until the school is back in session, at which time the clock will resume. So looking back at the language of our Senate bill, our new bill, we're now going to move over to section 56321. So we're going to look at that language. But again, we're not talking about the entire section. It's really just mentioning subdivision A. So I'm going to bring that language up here at the bottom. So subdivision A of 56321 is talking about if there is an assessment that has to be conducted, not only do we have to put together this proposed plan, which is what we talked about in the last section, this one says parents have to be given a written copy of that proposed plan within 15 days. So it's very similar. It's just now we've developed the plan. This section tells us that we have to deliver the plan to the parents, or the school district has to deliver the parents a copy of the proposed plan. But look, still embedded is not counting days between regular school sessions. So looking back at our Senate bill language that was recently passed, COVID closure days are going to be not considered regular school session time. So this clock won't apply during the closure either. We're effectively, again, stalling the clock, which makes sense because if the school district can't put together a proposed plan, how do you have one then to deliver to the parents? It does, however, say that the assessment plan must be developed within 10 days after the commencement of the regular school term. So this might speed up our 15-day clock, but I suspect that courts, in the aftermath of all this, when we're back to our regular life, sending our kids to school, the school districts may have a lot of catching up to do. If they're not able to put together assessment plans during the closure, and they're all just backing up and, clogging the system, so to speak, it's going to be really hard for them to meet all of these clocks, all of these deadlines. And that's something we as parents may have to be prepared to be more flexible with. But let's add this to our list of affected timelines. So you'll notice here at the top, our first was to develop the proposed plan. This one we just talked about was to give parents a copy of that proposed assessment plan. And again, we're not going to count days of COVID-19 closures as against that 15-day clock. But there is a provision that does say once school commences, now that plan has to be developed within 10 days. So that might speed up our 15-day calendar. But again, I would anticipate courts expecting a little bit more flexibility with parents if that's what the schools require. I don't know. I'm forecasting a little here without any precedent to back up what I'm saying. I'm just anticipating that we may have to be flexible with the school districts a little bit. Okay, so back to the Senate bill. Now we're looking at subdivision B specifically of our Senate bill. So we finished discussing subdivision A. Let's see what B says about our special education timelines. It's saying these timelines, the timelines we're identifying in this subsection, they're going to be waived. So usually waived means we're just giving it up completely, but that's not what this section is saying. We're waiving it only until regular school sessions convene. So during the closures, whatever timelines we're going to bring up in this, in B, these timelines are not even going to apply at all during the closures necessarily. So let's look at what those are. So our first section identified in subdivision B is 56043. And first let's look at N, because it doesn't say the entire section. It's asking us to look at N and O. So first let's look at what N says. This one is talking about a parent's right to examine school records and receive a copy of those records within 5 days of their request. So again, if you've taken my class at the law school, you know that a written request for records means the school has 5 business days to give you a copy of those records. That's waived. You can ask for the copies, and maybe that's something they can still give you. And I again, just like I'm forecasting that we as parents may have to give the schools a little bit of flexibility and forgiveness in trying to catch up on things, I also think the laws or the courts would look for a good faith effort on the school district's part. If there was a way for them to comply, even though it's waived, could they have complied during the closure and maybe mitigated the amount of cases or things that they have to, deadlines they have to meet upon opening? Could they have mitigated some of that by delivering or trying to meet the timeline even though it was waived? Or at least if they can't do it in 5 business days, maybe they now get 10 or something, right? So, all right, so now let's move over to subdivision O of section 56043, and let's bring up that language. So subdivision O is looking specifically at a pupil who has moved from one school district to another. Now the former LEA has to send to the new LEA the child's special education records within 5 working days. That's the language of the law, but our Senate bill is waiving that as well. So if you had just moved your student, or if you decide during the closure to move your student to another school district, there may not be a way for the school districts, at least by this Senate bill, they're not required to send that record within 5 days. Again, I would look for a good faith effort, but that's me reading between the lines. The courts may not do that. But effectively from the Senate bill language, your former LEA does not have to send that until, your former LEA does not need to send the records until the school session reconvenes. And that has been waived. So we're going to add that to the list. The transfer of special educational records from a former LEA to a new LEA, that's completely waived until school session reconvenes. So assuming that you asked for a copy of your records either before or during the closure, or you asked for the records to be transferred to another school district before or during the closure, technically the school does not have to do that at all during the closure. They can wait till the school's back in session, and now that 5-day clock will start. Or it will resume if it had already started before the closure. All right, so we've talked about section 56043, but our subdivision B here also points out section 3024, specifically subdivision A. So not the entire section, just subdivision A. So let's bring up that language. Here we're looking at something very similar, right? The language is almost identical. It's another section of law saying a former LEA has to send the pupil's special educational records to the new LEA within 5 working days. So this is sometimes the law does this in a statute or regulation. It will repeat itself in another section. It has done so here. So we're saying this one is also waived. It's nothing new, so to really add to our list. So let's move on to section 56504. Now you notice here, they didn't identify any subsection. However, when I looked it up, it is Any of the other subsections are merely just putting further descriptions on what subsection A means. So if you want to look that up, you can Google search that. But for now, I'm just going to show you what subdivision A says, because that seems to be the section that is really affected by our Senate bill. So here it says that the superintendent has to send a notice to the school's governing board within 30 days of determining some non-compliance. So our subsets 1, 2, and 3 below, these here are talking about different types of non-compliance that the superintendent may become aware of within his or her own school district. If they find that these non-compliances or the school district is out of compliance in one of these fashions, they have 30 days to send a notice to the governing board and have that looked into, right? So what are those non-compliance issues? Let's say if they see something that is not in compliance with IDEA, it is not following the law. If they fail to comply with a corrective action order, these will usually be issued through our State Department of Education as a result of a compliance complaint that may have been filed. If the Department of Education had in response to one of those complaints issued an order to the school district to correct something they had been doing wrong, and the school or the LEA is not complying with that, the superintendent has a duty to report that to the board within 30 days. And our last type of compliance listed in this section is the LEA's failure to implement a due process hearing order. So if there had been a disagreement between a parent and school district or student and school district that went to due process, a decision had been made in the parent's favor, and the judge of that due process hearing had made an order to the LEA to do something. If they don't do that, this is one of those times the superintendent has that 30 days to send a notice to the governing board. So those will also be waived. Which again makes sense. If the school is closed, if they are not in session, then how can the department investigate whether or not they're doing something? There's so many uncertainties as to how all of these educational services will be delivered, and a lot of the nature of these corrective action orders or a due process decision are so unique and specific in nature that it would be very difficult to deliver them the way they are designed and ordered during these closure times. So it makes sense to me that this type of a thing may be waived during the closure. So let's add that to our list. The superintendent is supposed to send a notice of failure to comply, but we're going to waive that. That 30-day clock will be waived. Again, it's not waived completely. It's only waived until the school session reconvenes, at which time that clock also starts again. Now subdivision C, so I told you we're going to spend most of our time on A and B. That's because this is what C says. All of this section applies to all LEAs. Even if an LEA continues to offer educational opportunities through distance learning or independent study or both during the period of time a school is closed. So even those school districts that have said, you know what, we're going to keep trying to educate our students during this closure, IDEA still applies to them. And those timelines will still apply, except for the ones that have been waived during this closure by this Senate bill, or by classifying this closure time as a time between regular school sessions. It stalls those clocks. So this applies to all school districts across the state. That's what C is saying. D then says that the legislature encourages local educational agencies to respond as expeditiously as possible to requests from parents. So think about that. What I said earlier, that the courts will probably look for a good faith effort on the school district's part, even though it says it's waived until reconvened or the clock is stopped until the regular school session is back. D here is kind of saying that same good faith effort, right? It's giving the courts the ability to say, could you have sent the digital copy of the child's records to the parents, even though the office was closed? Were people working remotely? Were you capable of doing that? And things like that. So if there is a way to carry out some of these, so even an assessment plan, maybe we just need to assess the child for their ability to learn through distance learning. Now, if we all put in requests for that, the schools will be completely bogged down, and I don't think they would be able to do that for all of our students. And all they have to do is do it as expeditiously as possible, or respond to the request. So it doesn't even have to say actually perform the request. It's saying respond to the request. So I still feel like there is some good faith effort on the school district implied in subdivision D, but it is saying they have to get back to you as quickly as possible given the situation. And this is a very unique situation, and the courts will consider that, I'm sure. Subdivision E, which is our last one in Senate Bill 117, says this section does not waive any federal requirements imposed under the Federal Individuals with Disabilities Education Act, or IDEA. And they can't. The state does not have the authority to waive federal regulations, right? That's federal law. This is a federal law. IDEA is a federal law, and the state has to put together regulations of how they're going to comply with that law, but they can't change or waive that law. So it's saying we're not waiving any of those requirements, but during this unique time, we're going to stop some clocks, or we're going to say the clock doesn't apply during the closure because it's really not feasible during the closure, but as soon as the closure is over, it's reinstated. So it's not completely waived, right? We're not waiving anything that IDEA says schools have to do. We're just effectively stalling or stopping clocks during this closure time. So that's all I had on that Senate Bill 117. But what I did want to point out to you was a couple days ago, I can't remember exactly if this was oh, there it is, the date's right here on the document. On March 21st, the U.S. Department of Education issued a press release. So here's the link to the press release. When you get there, if you click on this is purple now because I've already clicked on it. If you click on that, it'll bring you to a website like this. And it goes much longer. I've only, for our purposes, shown you the top of the page. But if you look down here at this highlighted in gray area, this is a statement by Secretary DeVos. She says, I was extremely, and for those of you who aren't aware, Secretary DeVos is the Secretary of Education. She says, it was extremely disappointing to hear that some school districts were using information from the Department of Education as an excuse not to educate kids. So what I think she's talking about here is on March 12th of 2020, the Department of Education issued guidance. They called it guidance on, excuse me, on how schools should respond in the closure to those special education requirements. Again, this is unprecedented times. None of us are exactly sure what is required by law of school districts during this time. But one of the statements that was made in that guidance document was that if a school doesn't offer educational opportunities to the general population, meaning students without IEPs, then they would not be required to provide special education services either. So I think what she's saying here is some school districts may have read that and said, maybe it's better for us to just not educate any of our kids during the closure so that we don't have to do special education either. And that was extremely disappointing to her, if I'm reading that correctly. She then goes on to say, and this is the part that I do really like, she says, this is a time for creativity and an opportunity to pursue as much flexibility as possible so that learning continues. It's a time for all of us to pull together to do what's right for our nation's students. And look at the wording she uses here. She says we have to be creative. That's so true. If there was ever a time for us to think, how can we provide services to children with disabilities who don't learn in the traditional way? How can we be creative in approaching that? This is the time. I'm always a big fan of creative teaching strategies, of modifying methodologies and delivery of services, if that's how it helps a student learn. And this is a time where that is needed more than it has ever been needed before, in my opinion. She also says we have to be flexible. And that's something we as parents aren't used to, right? We're used to IDEA telling us these are your rights, this is the timeline. If they don't do it, they're not in compliance. And there are parts of IDEA where we already have to be flexible. and flexibility is built into it. And that's what the rest of our discussion tonight is really going to highlight, is the ways IDEA already tells us we can be flexible. But I think we need to take that flexibility truly to heart. I think we need to push that flexibility. We as parents have to remember, if the law allows us to be flexible, this is the time for that. This is the time to forgive our school districts when they fall short, because there's no way they can keep up with everything that is required of them right now if we were to hold them to every timeline that and every everything the IDEA says we have a right to. Some of that we're going to have to be flexible with to make sure that some learning continues, even if it's not the best, even if it's not the most appropriate, even if it's not what they would have gotten if our kiddos were still in school. It is a time for us to pull together, to unite our efforts, to work collaboratively, and to be flexible. And so once you get to this screen, if you click on this link where it says new information, that will take you to a screen like this. So this is a supplemental fact sheet that was issued by the United States Department of Education, specifically the Office for Civil Rights and the Office of Special Education and Rehabilitative Services. So within this, they address a lot of things. And please click on the link to get more information about it. But I'm going to walk you through a part of it that is specifically talking about timelines, since that's the topic of our webinar tonight. So before we get to that, I want to point out some of the language they use in the preamble, if you will, the beginning part of this document. It says, again, they're talking about flexibility. So they're saying the Department of Education, we're here, we're ready to offer guidance, assistance, information on any available flexibility within the confines of the law. So there's already parts of IDEA that have flexibility built into it. And we're going to talk about what some of those are in just a minute. Another section talks about how the federal disability law already allows for flexibility. We just have to be willing to employ some of that flexibility. Some of that flexibility depends upon our willingness to say, yes, I will mutually agree with the school district to allow them more time, when I technically, by the language of the law, don't have to. Given this situation, courts, later on, if you are thinking, and I always tell my class, I'm not a proponent of due process just for due process sake. But if you are later on thinking of filing due process, the courts will be looking for your good faith effort to have mitigated the damages now, to have been flexible with the school district. I don't know that for sure, but I highly anticipate that being the case. So the law already allows for flexibility in determining how FAPE is to be provided. And that may have to be different in times of unprecedented national emergency, which is what we're facing right now. Another quote that I'd like to point out to you talks about collaborating creatively. So I'm a big proponent of creative solutions in and approaches to special education. And I tell my class at the law school all the time, the IEP is a team. It's meant and designed as a collaborative effort. But right now it's even more necessary for us to be collaborative. Far more necessary than it ever has been before. But it's always more beneficial for the student if we truly are collaborative. When we get adversarial, sometimes that's what it comes to, and that's what we have to do to advocate for our students. But they always get better services, and they get them sooner when we can collaborate together. And so that's something they're pointing out here, is this is a time to really think about being collaborative and being creative. Okay, so let's look at some of the ways. This, again, is part of the document issued by the Department of Education on the 21st of March, where they're pointing out ways the law has already embedded within itself, ways for us to be flexible. So these bullet points at the top are, here we're going to identify what the law says. What is the timeline we're talking about? So first of all, if a child is found to be eligible for special education services, we have to meet and develop their first IEP within 30 days of determining they're eligible. So we traditionally, under IDEA, it tells us that that's that 30-day clock, right? Once we found the student eligible, now there's 30 days to hold a meeting and develop an IEP so that we can get that child the services that they need. Another one of the timelines that points out is after that, every student with an IEP has a right to have it reviewed annually. So now we meet at least once a year to look at what changes need to be made to the IEP in light of what progress the child has made or not made during that year. So that's what the law says. Those are our timelines we're looking at. And here's where this area down here in the highlighted portion, this is the Department of Education pointing out how the law already allows us to be flexible. So the team can already within the law, it tells us we can agree to conduct an IEP meeting through alternate means. So I've told this to the students in my class. If the school district wants to hold the IEP telephonically, all they need from you is a signature saying, yes, I can do that. I'll let you do that. They need your consent. So they can't conduct an IEP meeting telephonically or not in person unless you as the parent or the educational rights holder signs the waiver saying, yes, I agree to hold it that way. So this is a time to exercise that, right? So it's a right you have not to, you can have it by telephonically, but you can also say, no, I want the in-person meeting. But if you want an in-person meeting during this closure, then you are going to probably be told, and I would guess that the courts would back the school districts in this, then we'll have to wait till the closure's over to hold that in-person meeting. So this is a way that the law already allows us as parents to be more flexible and to allow for some of this. So another thing is we can agree to not convene an IEP team meeting at all. And we can instead develop a written document that amends the IEP. So maybe we don't have to even do a telephonic meeting or a video conference. Maybe we can simply send a few emails back and forth. This is something you could do on your own. You could approach your school district and say, hey, given the closures, this is an amendment I'd like to make to my student's IEP that I think might help the delivery of service to better meet his needs or to make his education meaningful during this time. You can do that. And within that, you can explain, I understand we can't have an IEP meeting right now, that those may be very difficult to hold even via video conference. So if we're able to come to an agreement just in this email, then I'll waive that right to the IEP meeting and we can amend the document once we reach an agreement through our emailing. That's a possibility that's already built into the law of ways for us to be flexible. The department also made a statement here. We encourage school teams and parents to work collaboratively and creatively to meet these timelines. So again, they are again pointing out the need for us to be collaborative. That means we may have to be flexible where we traditionally don't want to be flexible. I agree that IEP meetings in person are probably much more productive. I don't even know if much more, but they probably are more productive than via video conference. But right now that's not a feasible option for us. So we have to be collaborative in allowing for some of these things. The school districts are going to have to be more creative than they may be used to being. In order to make sure that whatever distance learning they are offering to special education students is provided in a way that creates meaningful benefit. That's going to take collaboration and creativity. So another thing that the Department of Education points out is reevaluation. So there's a timeline already in IDEA for those, right? If we're doing reevaluations, we have to have that done at least every 3 years. For those in my class, you also know that you have a right as a parent to ask for it annually if that's what's appropriate. But at the very least, it has to be done every 3 years unless the school and parents agree that it isn't necessary. So maybe you can agree it's not necessary right now. That's one way. But another way that the Department of Education points out is we can conduct what's called a reevaluation by reviewing existing data. So if we've got old evaluations that might paint a picture of how the student's doing now, even though it doesn't give us a current snapshot, it may still be valid enough, not that old, may still be information that would be, a lot the same if we were to conduct it right now, another formal evaluation right now. They can just review past data is what I'm in a complicated way trying to say here, if that's appropriate. So maybe you can point out to the school district from a recent past evaluation, something that you're like, look, given this that we know about the child, combine that with distance learning, which is what's required of him now, maybe this points out enough of how we need to create a different solution or amend the IEP to make this distance learning more meaningful. So past data can be a form of reevaluation if it needs to be, and it can be done without a meeting and even without obtaining parental consent. And that's already written into the law, right? We've got the citation right here, section 300-305 sub A. And really think about that. There's no reason they need your consent because all they're doing is looking at information that they already have. They're looking at old evaluations that they've done, hopefully not too old, but past evaluations. It's information already probably in the student's educational record. So all they need to do is pull up their old assessments, read through those, and find out, does this still give us a somewhat accurate picture of the child? And given the situation that's occurring right now, that may be the appropriate way to conduct an assessment. Now, in traditional times, when the schools aren't closed due to a public health emergency like this, I, as an attorney, would tell you, don't ever let them, not ever, but be very cautious of allowing a school district to only use old data to call it a reevaluation, because usually our kids do change over time, right? Their skills get better. Sometimes their skills don't get better. And we need to have that measurement of how much did they or did they not improve. So up-to-date assessments are usually very important, but when appropriate, given this situation, it may not be as appropriate right now. So another, again, just ways that the law already has embedded within it the ability for us as parents to be flexible. I'm going to go over this section fairly quickly. If you filed a state complaint, usually there's a 60-day timeline for complaint resolution. That can be extended if exceptional circumstances exist. So the department can extend that whenever they want to, as long as it can be justified by an exceptional circumstance. And I would venture a guess that COVID-19 closures are an exceptional circumstance. For due process, there's certain timelines, like holding a resolution meeting within 15 days. But the law allows parties to agree in writing to waive that. So all we have to do is say, you know what, I agree. I'll be flexible here. I'll work with you and I will waive that. So embedded again within IDEA is a way for us to be collaborative and flexible. There's also a 30-day resolution period. Again, if mutually agreed upon, the timeline can be extended because of an unavoidable delay. COVID-19 closures present to us probably one of the best reasons to justify that the delay is unavoidable, and all that's required is that both parties agree to extend the timeline. So this is, again, asking you as parents to be collaborative and flexible. Another thing is that once a hearing is held, a due process hearing, a decision has to be issued within 45 days. And here the hearing officer can grant a specific extension at the request of either party. So embedded within that, either party just has to make the request and it can be extended. So that's another way that the law already allows for these timelines to be more flexible. The last thing that I want to show you, and at the end of this, I'm going to have one screen that shows you all of the links that, excuse me, I've been bringing up tonight. So this one was specifically issued by the California State Department of Education. And it was, I believe, on the 22nd of March, if I remember right. And it was guidance during these closures. And it's worth taking a look at, especially if you're in California. One of the things I want to point out, actually, I'm going to skip over that part. Here, this is a quote taken from the from that website, excuse me, from the website, it says the state is saying until and unless we're provided more flexibility. So there's already flexibility built in the law, but unless the federal Department of Education provides some sort of flexibility more than we're already given, LEAs have to do their best to actually adhere to IDEA to the maximum extent possible. So let's stop right there. They have to do their best to follow IDEA. So we've already pointed out ways that the law allows for us to be flexible. Where it doesn't allow for flexibility, they still have to do their best, but it's only to the maximum extent possible. We can't hold school districts to impossible tasks and to impossible standards, especially in times like this, where everybody's trying to do what's best, but we don't exactly know how to do that because this is something we've never had to do. So I'm sure if anybody does bring cases after this, this type of language to the maximum extent possible. And again, this is just guidance. This is not, controlling law, but it does point out the courts will likely take into account the situation. We can't expect somebody to do the impossible, or an organization like a school district to do the impossible. Something else that I want to point out from that document is that they say, in general, the California Department of Education is going to consider the time the school district is closed due to COVID-19. We're going to classify those as days between the pupil's regular school session, which from the beginning part of our webinar tonight, I pointed out to you, a lot of those time clocks stall or stop during those days between regular school session. So for our general purposes, that's what this will be classified as. This is a type of closure we've never had to classify before. And so the state has classified it for us, saying this is going to be considered time between regular school sessions where many of these clocks stall. And some of those that don't stall, we're effectively waiving, right? That was our subsection B of Assembly Bill 117 from the earlier part of our discussion. For annual or triennial IEPs, the California Department of Education will take the exceptional circumstances causing the delay into consideration. So if you've got an IEP, be it an annual or a tri, that should have fallen during this closure time, the state will take this COVID closures as exceptional circumstances. They're going to take that into effect in any decision they have to make about whether or not the school was in compliance, which is why my plea is school districts to do their good faith best effort to comply wherever they can. But if they're just too busy trying to provide educational services to hold an IEP meeting at the exact date, do your best faith effort to hold it as soon as you can. And my other plea is for parents to be flexible with the school district. Sign the form that allows the school district to waive that, because there is a way for you as parents to say, all you have to do is sign a form that they can send to you that says, I know this is my right to have the IEP meeting on this date, but I'm going to waive that time clock. I'm going to extend it. And that's the type of flexibility that and collaborative effort that I think we all need to be looking at here. Especially if the school district has tried to provide services to your child and is trying to better the distance learning that they're employing to all of their students, including the students with disabilities. Maybe holding these annuals and triennial IEPs is not the best use of their time. It's obviously an individual decision based on what types of things were or need to be discussed at your IEP. But again, be flexible where you can and work collaboratively whenever you can. So as I told you earlier, at the end, I was going to put up a slide that had all of the links. So this would be the slide. This has all of this. Top one is the Senate bill that passed here in California that we talked about in the very beginning of class. And then the press release issued by the Department of Education, our federal Department of Education. This is that last one we just looked at, the state's special education guidance during these COVID-19 closures. This is the section that I skipped. It is a way for you to reach out to your senators and your representatives in Congress to let them know how you feel about some of the new laws that are being proposed. So if you have the desire and you want to make your voice heard about how important special education services are, this would be the links to go to get some more information on that. And that is the end of our meeting tonight. So thank you for joining us in this webinar. And stay posted, look on our Facebook page because we will be having more webinars in the future to bring you more information, especially during this COVID-19 school closure crisis time. And have a good night. Thank you.